streaming in from the waiting room. Hello, welcome, welcome. Hope everyone's having a cozy Friday in December. My coworker Maureen so far wins the most festive Zoom background going on. But yeah, as everyone gets connected to audio and video, we'll give it a moment before diving in and going over what we're learning about today. In the meantime, I can cover some housekeeping items, though I suspect most of us are Zoom pros after this year, but you never want to assume. So we do have the transcript or closed captions or subtitles feature turned on. So you can toggle that on or off if you want to see the words on the bottom of the screen. You can turn that on, or if that's distracting, you can turn that off. To do that, the three dots, the ellipsis, more on the bottom of the screen, click that and you can choose your options there. On that same menu bar at the bottom, there's right in the middle, the chat function. That's going to be our communication method to ask questions, have comments of our expert speaker today. And I invite everyone to give it a test round and use the chat to let us know where you're tuning in from. So if you click that chat button, it'll pop something up and you can type in where in the country you're located. Let's see, I think that's about all of my housekeeping items. Oh, as the robot lady might have mentioned when you joined, this is being recorded, so it will be on our website and our YouTube channel in about a day. And that's so I invite you to, watch, share your whole attention, take some notes, and just know you can always go back and watch the recording or speed through and rewatch sections that you have questions on. Wonderful. Well, wonderful to see everyone and see where everyone's tuning in from today. We do have some, in addition to our guest speaker expert, Phoebe Harris, we have some additional folks on the line. And if you could wave, I want to say hi to my colleague Maureen Simmons and my colleague Debbie Rich. Hello. And then we have some members of the PMD Alliance Philanthropy Advisory Council. So I see Peyton Davies. And I know she's in Arizona, and I wanted to introduce them. They are an important part of our work at PMD Alliance. How are we funded? How do we offer all of our programs for free? It's through the generous contributions of individual donors, and the team that I just introduced, they head up and lead our philanthropy efforts. So if you have questions, if after this presentation, you want to ask specific advice or have specific conversations, those three would be your go-to people. So wonderful. Well, I think that we are ready to get started. So it's my pleasure to introduce you to our guest speaker, Phoebe Harris. Phoebe's an attorney practicing in Greater Tucson, Arizona, Green Valley to be specific. And Phoebe, why don't you tell us a little bit about yourself and introduce yourself to the gang here to get us started.
Absolutely. Thank you all for having me again. I was thrilled to be asked to come back after my original speaking event that was October 22nd. I think I was asked to come back because we never got to cover trusts. So we primarily focused on the lifetime documents, powers of attorney. So I was very humbled and very honored to be back with you all. I practice law here in Green Valley in Tucson. I am a Tucson native. I practiced law with my father, Walter Henderson. I joined the firm in 2008 and licensed to practice here in the state of Arizona 2009. I was originally licensed to practice in the state of Washington. My husband was with the 2nd Ranger Battalion out of Fort Lewis. So I originally sat for the bar in the state of Washington and practiced there as corporate in-house counsel for a biometrics corporation. But my husband's job relocated us back home here to Tucson, and I was lucky enough to join my father's firm. I do think that maybe a little bit of nepotism had to do with that, but I absolutely love it. So we primarily focus in estate planning, wills, trusts. I handle all the litigation for the firm. So I do all of the wills, trust contests, guardianships, conservatorships. I do like the litigation side of things. So that's a little bit about me. Absolutely love living down here and being home again and practicing with family, of course.
Wonderful. And as you mentioned, the October program, we everyone had such great questions. We didn't cover all the content, so we're so grateful that you came back. But I do want to share the link. So if Kelly, if you could put in the chat the link to the recording of the previous session. So if you have questions about let's see, those lifetime documents, the power of attorney, living wills, DNRs, Medicaid planning, probate. Please watch that. It was a great conversation with Anissa and went into great detail. And I think where we left off was to start talking about some of the after death documents. But Phoebe, I think maybe if there's some baseline knowledge, anything that you want to start with to get us going. And prior to letting you all in from the waiting room, Phoebe said, I want lots of questions. Don't hesitate. Put them in the chat. We want to make this, it's not naturally, the most exciting topic, but what could be more exciting than, and more important than what happens and, what happens with your estate. So please do, this is your chance to ask questions, be interactive. As they come up, put those in the chat and I'll relay those over to Phoebe. And also I'll just mention that, of course, every state is different, every individual case is different. So this is an educational starting point. You will need to see your own attorney, talk to your own team, but just some educational background to at least get us started to talk about the topic is what we're here for today. So where should any kind of baseline knowledge that you want to set the tone with, Phoebe, before we dive in?
Sure. What I'll do is I'll kind of do a recap of what I talked about last time. If there are any specific questions or follow-up questions from last, the speaking event I did on October 22nd, feel free to put those in the chat. Also feel free to email me. I can answer those questions. But really last time we did like estate planning basics, estate planning essentials. So we talked about the lifetime versus the after death documents, the most important documents, of course, during lifetime, your powers of attorney, financial power of attorney, healthcare power of attorney, mental health power of attorney, and living wills versus DNRs, do not resuscitates. And talking about the court version of that, I stressed last time that should you fail to plan for yourself or fail to have these documents in place, the laws of each state provide alternatives, or they provide a plan for you, whether you like it or not. So should you need someone appointed during your lifetime to handle your financial affairs and or your medical or personal affairs, the courts, of course, have statutory procedures to appoint a guardian and conservator. Some states just call it a guardian over the person and guardian of the estate of the person. So we delved into that and talking about how you need to control your own fate or your own inevitable that, one day you may become incapacitated, you may become unable to handle your own medical, personal, financial affairs. And as such, you should have these lifetime documents in place. We also talked about the segue. I actually rewatched it, the video this morning. The segue was, we were talking about free dinner and lunch seminars, how everyone says that the only way to avoid probate is to, of course, have a trust. And I dispelled that untruth. It is an untruth. And we talked about beneficiary designations, transfer on death, payable on death, beneficiary deeds. We talked about how to avoid probate without a trust. We also talked about a will. What does a will control? What does probate mean? Also, if you fail to make any of these, they're called non-probate transfer designations. So any account in joint name, transfer on death, payable on death, named beneficiaries, those are non-probate transfer designations. If you fail to do so, the law, again, has its own default and its own backup to handle things for you. And it says who inherits what, and each state has what are called intestate succession statutes. So we were really stressing the fact that if you want to control who is in charge during your lifetime and what happens to you during your lifetime, how your wishes and your directives are followed by the people you trust and love. And then, of course, after you pass away, making it easy for those that you leave behind, and providing the proper instructions, avoiding probate, making it as simple as possible. You can absolutely handle all of that on your own by and through having proper lifetime and then proper after death documents. So the one thing that we did not get to talk about were trusts. So trusts are a whole legal beast in and of themselves. And I think the best way to start off with a trust is number one, to define it. I mean, what is a trust? So a trust is a thing. It is not a person. It is not an individual. It is nothing of that sort. It's almost people. I always tell my clients to equate it to like a corporation. It's a thing. So if the CEO of McDonald's dies, McDonald's doesn't die, McDonald's continues. A trust is the same way. A trust is a thing. It's something that you create. It's a legal creation for you to essentially transfer all of your assets into the name of the trust, and the terms of the trust document then dictate and control those trust assets pursuant to the terms of the trust. So the person who creates a trust is called a trustor. Some states call them a grantor. Some states call them a settlor. And then, of course, the person who administers or is in charge of the assets is called a trustee. So when you create a trust, you are the trustor. And in general, if you do a living trust or a revocable trust, you are the trustor and the trustee. So you're the creator and the administrator. Also, during your lifetime, you're the sole beneficiary. So you're creating this trust saying, during my lifetime, I'm going to put all my assets into this thing that will survive me, will continue on after my passing, will continue during any period of incapacity. And I put all of my assets in it because I created it. I'm going to be in charge of all of my assets so long as I am capable. And of course, I get to reap the benefits of all of my assets so long as I'm alive. So that is a trust. A trust is a thing that you create to hold, manage, control, and dictate all of your assets. So that is essentially where the play on words with these free dinner and lunch seminars, how it avoids probate. So how does a trust avoid probate? Because those assets, once I transfer those into the name of my trust, a trust can never die. A trust is a thing. So that's how a trust avoids probate. So just as we discussed last time, having a named beneficiary. So yes, the assets in my name alone, but at date of death, it says that it automatically goes to this named beneficiary. So that is a non-probate transfer. Another non-probate transfer is transferring assets into the name of a trust, because a trust can never die. A trust is a thing. The other cool thing about trusts is that a trust is also kind of a hybrid. It is effective during both your lifetime and after your death. So the trust is essentially a vehicle or a pot. I like to tell people, think about a big melting pot and you're putting all of your assets into this pot. That pot is the trust. Okay, so the name of the trust. So once those assets are in the name of the trust, and let's say I become incapacitated during my lifetime, my named successor trustee under my trust has access to all of those assets. So they can pay my bills because they're the successor trustee. They are in charge of any and all assets titled and held in the name of the trust. So during my lifetime, throughout any period of incapacity or I can't handle my own affairs, my successor trustee can take over, can manage everything for me, handle all those assets as a trustee. And then, of course, if I pass away, that same trustee continues on. And my trust says, this is how all of my assets shall be handled during my lifetime. And then, of course, when I pass away, this is how all of my assets go out. So that's a trust. Very quickly, and I just want to kind of hammer this point to everyone. Currently, right now, we have a trust administration where the trustor puts some of his assets in the name of the trust, but he was under the assumption or presumption that once he signed the trust, all of his assets were automatically in it. No. So he put, for example, we put his house into the name of the trust. It's actually called a deed to trust. You actually deed your home into the name of your trust. Of course, you are the trustor, you are the trustee, so nobody's going to sell your house from out from underneath you. But you need to retitle all assets into the name of the trust for the trust to control those during your lifetime. You can name the trust as a beneficiary under an IRA, for example, or a life insurance policy, but you have to fund the trust. Just because you sign a trust document does not mean that all of your assets are in it. So our client, we took care of his real property. We sent him a letter saying, transfer your bank accounts, your investment accounts, anything else that you want controlled by this trust into the name of the trust. He always told us, yes, I did that. Yes, I did that. Well, upon his death, his bank account was not in the name of the trust. An investment account was not in the name of the trust. And so then those assets were in his name alone. And so we had to open a probate, and his will left everything to his trust. So when you create a trust, it is extremely important that any and all assets that you want to be controlled by that trust are retitled into the name of the trust. That's the only way a trust controls those assets. So that is of utmost importance. I wanted to get that out of the way because this case just kind of bothered me. So who needs a trust? All right, so we've already dispelled with the myth that everyone needs a trust because it's the only way to avoid probate. We all know that's not true, so not everyone needs a trust. So who does need a trust? We counsel our clients that in general, there's 5 categories of people who need trusts. First is for estate tax purposes or estate tax implications. So the state of Arizona has no inheritance tax and no estate tax. Okay, and I did a little bit of research, and there are only 17 states that actually have estate tax and or inheritance tax. So there are 11 states with the estate tax only, where the state actually charges estate tax as well. That is Connecticut, Hawaii, Maine, Massachusetts, Minnesota, New York, Oregon, Rhode Island, Vermont, and Washington. Also the District of Columbia. So they only have just an estate tax. Those states that only have an inheritance tax, so they actually charge a tax on the person inheriting money, are Iowa, Nebraska, Kentucky, New Jersey, and Pennsylvania. The only state that charges both an estate and an inheritance tax is Maryland. So I don't know if anyone in the chat said they were from Maryland, but just warning, if you're in Maryland, they have both an estate tax and an inheritance tax. So back to the state of Arizona, we have no inheritance tax, we have no estate tax. Obviously, we are a large retirement state, and that is a selling point. Texas is the same way, Florida is the same way. We want to lure the retirees here by, of course, having very, very favorable estate and inheritance tax laws to where we don't charge any. So the federal estate tax, right now, for 2022, the federal estate tax exemption is going up per individual to $12.06 million. So in other words, you are not subject to federal estate tax unless you have a net worth, a total net worth of 12.06 million or more. Okay. For married couples, you need to be worth over $24.12 million. So a lot of people are getting away from trusts because the federal estate tax exemption is so high. So if the federal estate tax exemption were to revert back to what it was after it lapsed in 2010, so $5 million exemption per person adjusted for inflation annually, an individual would have a $5 million exemption, married couple would have a $10 million exemption. So if your net worth is under those amounts, you don't need a trust to avoid federal estate tax, because federal estate tax will not be implicated in your estate anyways. So one reason for a trust, you're going to be subject to the federal estate tax. You want to minimize federal estate taxation. You want to maximize the monies going to your beneficiaries and decrease the amount you're paying the government. So that's one reason that you need a trust. The second reason people need trusts is a split family, so a second marriage. So it's your second marriage, you have children from a previous marriage, your spouse has children from the previous marriage, and you are concerned that your spouse might cut out your kids when you pass away if you're the one who dies first. So a trust can allow you to do that. A trust can say, if I die first, X amount of assets go to my children, or X amount of assets are held for my spouse's benefit, but my spouse can never change who gets that once my spouse dies. So family dynamics, split marriages, children from previous marriages, that's one reason to have a trust. Then a third reason to have a trust, assets. So like a variety of assets, various assets that require a trust. Where we run into this most is real property. So we have a client that owns property in Arizona, in Washington State, Illinois, and Maine. Well, if those 4 states don't all have beneficiary deeds or don't recognize beneficiary deeds or transfer on death deeds, you have to have a trust, okay? Real property shall be probated in the state in which it is located. So if we have clients that have properties all over the nation, it's best to have a trust, and then you put all of those deeds into the name of your trust, thereby avoiding a probate in numerous states. So sometimes your unique assets require you to have a trust. I had a client, he had family farmland, family ranch in a state that did not recognize beneficiary deeds or transfer on death deeds. So we had to create a trust so he would avoid a probate in that state. So we created a trust just specifically for that one piece of real property. Worked out great and avoided a probate in that state. So you have federal estate tax implications, split families, asset implications. The third is beneficiary implication, or fourth is beneficiary implications. So if you have a child with special needs, you have a beneficiary that may be a minor or underage. You have a beneficiary that might be a spendthrift and you don't trust them with an outright distribution of money. Sometimes you need a trust because your beneficiaries require it. You have a child, special needs child. Well, obviously they can never manage their own money. So if you pass away in that trust, it appoints a trustee to take care of that child's money and to continue providing for that child for their lifetime. So sometimes there are beneficiary situations that require a trust. Old English law, it's kind of old verbiage in the law. They call this dead hand control. So if you want to control your money after you're gone for years and years and years later, you need a trust. A trust is the only way that you can do that. So we have had very creative clients that want to control the monies for quite a many years after they pass away. You can have whatever restrictions, implications, requirements, qualifications, anything you want in your trust, subject to some things that are unconstitutional or illegal. But for example, we had a client who had a child that suffered from substance abuse. The child was clean as of our client's date of death. However, the probability of relapse was quite high. In the trust document, our client specifically said that this child shall pass a urinalysis test annually prior to any distribution of trust monies. Our client wanted to make sure that the child was not going to use the monies to buy drugs, long story short. Also wanted to make sure that the child was turning their life around and that their sobriety was real. It was not going to be subject to a relapse or something of that nature. We also have clients that leave monies to grandchildren or children for their higher education. You can get as specific as you want on that one. We have a client that actually has a GPA requirement that, my child shall maintain a 3.2 GPA or higher at a 4-year college and must graduate before attaining the age of 25, and the trust will pay all college expenses. However, if that child does not have a 3.2 or higher, then it looks like they're looking at student loans. So you can get as specific as you want. I will say that this feature of trusts is probably the most enticing for people, is that, they worked hard for their money and they want to make sure that their money truly benefits those that they are leaving it to. And some people, depending on age or maturity, and really doesn't matter how old you are, level of maturity and common sense don't come with age. They want the trust to then assist them in becoming an adult, assist them in becoming a productive person, a successful person. They don't want their monies to simply just supplant any income that the beneficiary might have. And they also don't want to see their money squandered. We have seen outright distributions of a lot of money that are quite literally gone 9 months after someone passes away. So if you believe that anybody you might leave money to might squander it or might be a spendthrift, it's best to have a trust. Another situation for a trust, when talking about beneficiary situations, we see this too. If your beneficiary has creditor issues, so your beneficiary filed bankruptcy, a couple years ago, maybe started a small business and it didn't work out and they had to file bankruptcy. Well, any monies that they inherit could be claimed by their creditors. So in the trust, they actually avoid that by having it being held in the trust. Therefore, the beneficiary does not own it personally, and it is not subject to creditor claims. So trusts are the best and truly the only legal avenue to go down when you want to restrict or qualify or control the monies after your passing. So, and then the fifth situation, honestly, we just have some clients that just don't believe us that you can avoid a probate by non-probate transfer designations and beneficiary designations, and they just have to have a trust. So, okay, we do a trust. So, so those are really the 5 situations: federal estate tax implications, family dynamics, split families, second marriages, asset dynamics, you have real property in numerous states, beneficiary situations, and then when you're just absolutely convinced that you have to have a trust to avoid probate. So really those are the 5 situations.
And there was one question that I think is kind of relevant. So this person says they're not a millionaire, they don't have a ton of assets. Is there a minimum, asset size that makes that a factor?
Absolutely not. Absolutely not. We have clients that have trusts and they have a minimal amount of monies. We have clients that have trusts and they have a bunch of money. We have clients that actually create trust just for specific assets. So but going back to my client who had the family farmland in another state that didn't recognize beneficiary deeds, you can do that for any account. So again, a trust, and this is the legal concept that some people miss sometimes. A trust does not control people. A trust does not control, your doctors or your healthcare decisions. A trust only controls assets that are titled and held in the name of the trust. So let's say that you have a smaller bank account, savings account, let's say $20,000, and you want that to go to a specific friend or a grandchild. You can actually create a trust and just put that one savings account in the name of the trust. So that trust only controls that little bit of money. Everything else you could have going out other places. So people do that. They will create a trust just for a specific amount of money or for a specific account. There's absolutely no monetary qualifications whatsoever. It's just, is there an asset? Is there a certain amount of money? All your monies, is there anything that you want to control or dictate or qualify after you are gone and not just hand it outright to the named beneficiaries? Sometimes handing a beneficiary a large check outright is not the best idea. Most of these trust situations come into play with minors or younger children. You really don't want to hand an 18-year-old a $100,000 check. They will run out and buy a Corvette and a Mustang and won't be able to afford the insurance on them. So some people do that to kind of protect the beneficiary from themselves. So it's great. And with the unique aspect of trust of making them very personal and very specific to that beneficiary is great. So for example, a lot of them in like the education realm, for example, they'll say, okay, the trust monies will pay for any and all college education this beneficiary may need, but the beneficiary shall first try to get scholarships and first try to get grants and everything else. You're not just going to go on a free ride to Harvard because you have trust monies if you could get a full ride. So, there's things like that. And it really does make the beneficiary more accountable. It also allows the beneficiary to understand the benefit of having monies, to learn how to invest monies. What is an investment? What is an investment account? What is a stock, a bond? So many of these people, the beneficiaries, don't know that. And as such, it can be squandered. In that same breath, predators. I have a couple clients who have created trusts for their children because they don't trust their in-law. They don't trust the son-in-law. They want to leave daughter $1 million, but they don't trust the husband because they know the husband is going to think that the $1 million is his. So they actually create the trust to keep things separate, to keep things apart from the beneficiary, not giving the beneficiary 100% control. Again, going back to what I said, the only person who controls the trust assets is the trustee. The beneficiary can have a say or be involved. Obviously, they get to know about their beneficial interest in the trust, but they don't control it. So, daughter comes up to the trustee and says, I need $250,000 to buy a house and I want to put it in joint name with my husband. Trustee says no. Trust document says any and all distributions shall be for daughter and daughter's sole and separate benefit. So sometimes people create trusts or these qualifications and restrictions to almost protect the beneficiary from themselves or protect the beneficiary from people that they don't see as predators, but mom and dad do. So it goes that way. So that's the greatest thing about trusts. Trusts, as opposed to wills or beneficiary designations on accounts, again, the dead hand control. It can be dictated, it can be customized, it can be as unique as you are. When you name beneficiaries on a bank account, they just quite simply get a check. What they do with it, it's up to them. You can't control it, it's theirs. And yes, you avoid probate, but that's cash in their hands. So that's the good thing there. So then I know that before we run out of time, because I want to get to everything on these trusts for you guys. So I know that in the chat from the last time, everybody was talking about asset protection. So what do trusts offer in terms of protection? Creditor protection, asset protection during my lifetime. If I'm the trustor and I create this, if I create a trust, I've had clients come in and tell me, I created a trust, I put all my assets in the trust, and therefore, if I get sued, nobody can get those assets. Wrong. Absolutely wrong. A trust does not create any automatic, any basic, any universal protection from creditors. Why? Going back to what is a trust? Who creates it? A trustor, me, and I put all my assets in the name of the trust. I'm the trustee and I'm the lifetime beneficiary. That is what is known as a grantor trust. In other words, it's mine. Just because it's in the name of the Phoebe Trust, it's still mine. I can access it. I can withdraw all the monies. I can, go to the casino with all the monies. It's my money. I can do whatever I want with it. So if you have control unilateral control, unlimited control over the assets you put into a trust, then somebody who sues me can not only sue Phoebe, but can get Phoebe's trust, because the trust is really Phoebe. It's one and the same. For example, when you go to transfer your bank accounts or your investment accounts into the name of your trust, it still uses your social security number. It's you. Yeah, your checks change to the Phoebe trust. Phoebe is trustee, but it's still Phoebe. I mean, it's still my signature. It's the same. So revocable lifetime living trusts, where the grantor retains any sort of power, any sort of control over the assets, or is serving as a trustee, do not offer any sort of creditor protection whatsoever. So what trusts do? The only trusts that provide lifetime protection from creditors, asset protection, are irrevocable trusts. In other words, you create a trust that you can never change and that you can never control. So if you have an extra $1 million and you know that you want it to go to a grandchild that has Down syndrome, and you want to provide for them for the rest of their life, you could create an irrevocable trust where you take the $1 million, you put it in the name of that trust, but I can never access it. I can never benefit from it. I don't even control it. That $1 million is now outside of Phoebe. So if Phoebe gets sued, Phoebe doesn't have access to the $1 million. That's how trusts create protection. So going into creditor or asset protection after you're gone, see the beneficiaries. If you do not allow the beneficiary to have unilateral access, control over the monies you're leaving them, it automatically has creditor protection. So that's going back to where a lot of my clients will create a trust for their child, because their child might have quite a few creditors. I have a client who didn't need to have a trust per se, had one son, leaving everything to him. He's a great guy, but he was going through a really nasty divorce. And he also had a couple, outstanding liens, judgment creditors. Well, if she left everything to him just through a beneficiary designation, his creditors, yay, he has money to pay us off. So what my client did was create a trust until all of his litigation, all of his legal issues subsided, and then instructed the trustee, well, then give it to him outright. But don't give it to him if he's going to lose it to his existing creditors, or those creditors existing at the time of my death. So that's a good way to do that. So you can protect the beneficiaries from their creditors. But in terms of lifetime, you creating a trust and believing that if you put all of your assets into the name of the trust, it automatically protects you, it does not. If you have access to the monies, if you have control over the monies, your creditors can get it. That's just default of the law. So Medicaid, or state-sponsored forms of Medicaid, people will say, okay, I'm going to create a trust for Medicaid planning. So, and unfortunately, I'm going to have to kind of punt this discussion because each state is extremely unique and dynamic, and I mean, to be honest with you, confusing as to their Medicaid qualifications, where the state picks up and the federal government doesn't, who's disqualified, who's not disqualified, what assets are countable, what assets are not countable. So everything I say in this area is just kind of big, broad strokes, because you really need to figure out what qualifications your state has and what they count, what they don't count, etc. People will create, so in the state of Arizona, you can create kind of like an irrevocable Medicaid trust where you put certain assets into it to where those would be protected or considered non-countable assets to qualify for Arizona's long-term care services or access Arizona healthcare cost containment system. There are many hoops here and many warnings. There is a 5-year look back in the state of Arizona, not only from the federal government for Medicaid qualification, but also the state's Medicaid system. So in other words, if you intentionally try to bankrupt yourself within 5 years of needing long-term care, they're not going to pick up the tab. So I always give clients this example. So if Bill Gates all of a sudden gifts away all of his money or creates all these irrevocable trusts for all of his kids, and all of a sudden he's broke, and he does it, and then he applies for long-term care a year later. Well, they're not going to pick up his tab. He has plenty of money. He just intentionally bankrupted himself. I had a client who was going to do that. She was going to give away all of her assets to her children. I mean, her home, retitle it in the kids' names, her vehicle, all of her bank accounts, everything else. And she knew she needed long-term care. I mean, she knew that she was going to be going into a skilled nursing facility or an assisted living facility within 6 months of doing that. And, I simply told her, if you do that, don't be shocked if your application is denied, because you have about $1 million and 6 months from now, you're going to be broke. That's kind of a red flag in terms of qualifications. So very important to understand that with Medicaid qualifications, or state aid to pay for your long-term care, understanding your state's requirements. So are you in a community property state? Are you not? And what are the countable versus not countable resources? So the state of Arizona does not look at your total net worth if you're a married person. They only look at your community half. Then there are certain assets that are not countable. They don't take those values into consideration. So for example, your home, vehicle, all tangible personal property, any and all separate property of your spouse. So, a lot of people say, well, with my house, I'm worth $500,000, but the house is worth $250,000. And then, well, we won't calculate a tangible personal property and vehicle. So then your liquid net worth, your countable assets is $250,000, but divide by 2, it's only $125,000 to you. So the state doesn't want to bankrupt your spouse, because then you're both in need of government care. So just to provide for the one, you of countable assets are required to spend down your countable assets, in our example, $125,000, down to $2,000 before you qualify. So in other words, you need to spend $123,000 on your long-term care, and then you would qualify. So when you go to an estate planning attorney or a long-term care specialist or something of that nature, really understanding what you would actually have to come out of pocket to spend on your own care prior to the state paying 100% of your care is extremely critical and extremely crucial. The other thing I always tell people to take into consideration with any sort of long-term care planning or Medicaid planning is don't ever forget your income. So I had a client, she said, well, I only have $200,000 and, at $7,000 a month, it's only going to last me X. I said, okay, so you have $200,000. How much money do you make a month? Well, between Social Security, her pension, her deceased husband's pension, and her investment income, she made about $5,000 a month. I said, okay, so then you're only dipping into your $200,000 at $2,000 a month. So it's going to last you a very, very long time. Mind you, at the time she was 94. So, I mean, if she could live to be 104, 110, but always take that into consideration too. So I always tell clients, whenever you believe you might need long-term care, you get a diagnosis of something, somebody starts to slip, you have a family history. I have clients that have generations of dementia and Alzheimer's going back, that it's always good to talk to a planner well before you actually need it. Because when you need it, I can only speak for the Arizona system, it doesn't happen right away. It's not automatic that you're approved. And it's not like, oh, you move into the assisted living facility and the very next month you're qualified and the state is paying for everything. So it's always great to come in well before that is needed. So not only do you have an understanding of what is going to be countable, what's not countable, what assets you're going to have to spend down, if anything, if you're going to have to create an income cap trust. So Arizona also has an income level. You have to have an monthly income of under a certain amount. You can actually create what is called an income cap trust, to where certain income that you get per month can be diverted to that trust. So then you qualify for the income requirements. So all those planning things, this is what somebody goes through with you well before you need assistance. Never advisable to wait till the last minute, and never advisable to, I'm moving into an assisted living facility 2 weeks from now. I only have $10,000 in the bank. What do I do? Those are rush situations. They happen. Life happens, but it's much better to pre-plan for all of that. So, in terms of with the trust and going into that, whether it's a grantor trust or an irrevocable trust, what trust assets are countable, what trust assets are not. All great things to review and discuss well before they are needed. I don't know, are there any other questions in the chat or?
Yeah. There's some questions since we're coming to this because someone is affected by a Parkinson's disease diagnosis. There's a handful of questions that kind of come at that from different angles about what if you are the primary caregiver, your spouse has a diagnosis. Is a trust a good way to manage assets and their income if the spouse becomes incapacitated or dies? Well, I won't ask you three questions at the same time. How about starting with that?
Okay, so one spouse or partner is diagnosed and will be in need of long-term care. The other spouse is fine and is a primary caregiver. So again, going back, speaking only for Arizona, Arizona does not want to bankrupt the we call it the non-needing spouse. So the spouse or the partner that is not in need of any benefit. We definitely want to keep that person in the home. We definitely want to keep them economically viable. So going to that, so when the person is in home, that's the other thing. Arizona's Medicaid program also prefers to keep someone in the home. So instead of going to a skilled nursing facility or assisted living facility, they do actually offer Medicaid benefits for in-home care because it's actually cheaper for the state for you to stay at home. So there's a lot of things you can explore in that regard. So should that in-need spouse have to go into a facility, the community expenses, monthly expenses, are actually taken into account. So it's not, countable resources versus not countable resources. It is this spouse that is the not needing spouse, the non-needing spouse. What monthly expenses do they have? You still have the home, you still have upkeep, you still have taxes, you still have insurance, you still have a whole bunch of things. So those are actually deducted then from the countable resources for the partner or the spouse that is in need. It is a big, long mathematical process. It's amazing how some people think that they will not qualify because of their overall general net worth or their monthly income. But once the access or the Altex agent or the worker who's assigned to your case actually runs through all the numbers, you'd be shocked at how many people actually qualify. Long-term care is extremely expensive, but the needs of the non-needing spouse are not put on the back burner or completely disregarded in that application process. With the income, for example, they take a community income and then, of course, community expenses, things that the non-needing spouse will still need even after the need spouse goes into long-term care. And then they redirect, where is the sources coming from? Is it a separate source of income? Was it a community source of income? And then are there any ways to get the needing spouse to qualify income-wise? That's going back to that Miller Income Cap Trust. I know it kind of sounds like I'm speaking Greek, but that's that the process is, believe it or not, a lot more straightforward than you think. It's essentially a financial audit. It's essentially a financial review. The state says, okay, send us, here's a questionnaire, what assets do you have? What income do you have? What bank accounts do you have? What are the relative values? Send us proof of that. Then it's almost like filling out a financial affidavit. How much do you spend on electricity? How much do you spend on gas, water, sewer? And it's all deductions. So as the non-needing spouse, the second someone is diagnosed with Parkinson's or something, any other diagnosis that might require some sort of higher level of care or skilled nursing, out of home care to live somewhere else, that is when you need to go talk to someone and they can kind of walk you through it. Also, I don't know what the national average is. I know that here in Green Valley, a very large retirement community, that the average for assisted living is anywhere from $3,500 to $4,000 a month. The absolute highest long-term care, which is skilled nursing, absolutely skilled nursing, memory care units, where all of the activities of daily living are covered by this skilled nursing facility. You're running anywhere between $6,500 and $8,000 a month. So, planning on that, and also doing a longevity analysis of your assets. So if you are I'm going back to that client who, I'm going to spend $5,000 a month at this long-term care facility, but she has $3,500 in income. Well, you're only dipping in $1,500. So doing kind of an asset longevity plan, looking at how much you make on your assets now, that's additional income. If you actually did have to invade the principal, how many months do your current assets provide for you? But also knowing that as that spouse that stays at home, that it's never the state's intent, and the state generally will not say, well, we're going to bankrupt both of you and you have to sell everything you own just so your spouse can go in and be covered by state aid. So what was the other question?
I think I can combine a couple. It was kind of, what about when to do a trust? Does it make it harder to sell property, to refinance property? Is it ever too soon?
Yes, and yes. Okay, so only speaking of state of Arizona. So state of Arizona, if you have a mortgage and it's secured by and through a deed of trust. So a deed of trust is essentially evidence of your mortgage, and it's recorded against your deed. Well, lenders here in the state of Arizona can only extend mortgage monies or loan monies to humans. Okay, again, this is actually a great question. So going full circle back to like my first part of trusts. A trust is a thing, it's not a person. So when you take out that loan, that mortgage company wants to attach that to a human, to a person. So Phoebe needs to take out the mortgage, not Phoebe's trust, not Phoebe as trustee of the trust. So then Phoebe secures the mortgage, and the deed of trust is recorded against my property. Then Phoebe, in the state of Arizona, being a title theory state, Phoebe can then transfer the property into the name of her trust. So now this thing is in charge of my home if I die or if I become incapacitated. Well, let's say Phoebe wants to refi. Well, Phoebe as trustee of trust cannot refi because I need to be a human again. So I have to take it out of trust, put it back into my name, do the refi, then put it back into the name of the trust. There are a lot of situations where clients are just like, that is way too many deed recordings. I'm not dealing with it. So that's a situation when you mention financing. Yeah, that can be a beast. There's also certain assets that can never be held in the name of a trust. For example, an individual retirement account. Individual, not a thing, has to be a human. So Phoebe's IRA always has to be in Phoebe's name alone. However, Phoebe can actually name the trust as a beneficiary. So when I die, that trust will actually control those IRA monies. But during my lifetime, the IRA must always be in my name alone. Other retirement schemes, 401ks, things like that, they always have to be in your name because they are linked to a human and never a thing. So too soon to do a trust? I'm sure there are situations where it is too soon to do a trust, but I think truly your testamentary intent, I mean, if you were to die today, where are your monies going to go? To whom and how? So if I died today, all of my assets are joint name with my husband or payable on debt to my husband. Okay. So if I die today, to whom? My husband. How much? Well, that's private. And then how? Well, non-probate transfers. He's going to own it outright and everything's his. And I'm okay with that. I'm absolutely okay with that. So whenever you think of this, think of that. To whom, how much, and how. So I am absolutely fine with everything going to my husband through beneficiary designations or joint accounts, and he just gets it outright. So if he, I don't know, wants to go buy a house in Montana and fly fish for the rest of his life on our money as well, that's fine by me. I'm dead. Oh well. So if you're not okay with that, So let's pretend that my husband and I had a child with special needs, and we say, okay, it's completely fine that joint accounts go to my husband or beneficiary designations, everything to my husband, but what if we die at the same time? Those monies cannot go directly to that child. I want to pick who is in charge of that child's money, who is in charge of that child's care. And that child's going to need a guardian, a conservator. If they're a minor, they have to have that. So is it too soon to do a trust? It truly depends on your situation. If you don't need to have much money at all to need a trust, if you have a situation like that, you have minor children and you want to be in charge of who's in charge of that money when they get it. Because if not, then if you do nothing, again, going full circle, the law will create a plan for you. And you will be in court with a guardianship and conservatorship. You will be in court with the probate administration. You will be in court for annual accountings by these court-appointed guardians, conservators, personal representatives. And to be quite honest, the only people who make a lot of money over that is the attorneys. And it's true. I don't agree with a lot of the things that some of my fellow colleagues do, but they make a lot of money off of it. The best way to save money, the best way to direct your money to the people you love and you control it is to do it now. And if that is a trust, because you do have minor children, you have special needs, I don't know, you don't really trust your spouse, it's up to you. Do it. Get it done now, because you're going to make it so much easier, not only for them, but also for the people who are in charge. So let's take the special needs child that you don't prepare for or you don't provide for. Well, let's say that my husband and I had a special needs child. His bloodline, so his mother and father, and my mother and father would be on equal standing to be the guardians and conservators. His parents are divorced. My parents are still together, but they're also all, 70 plus. They might not want to take care of a minor child. All right, so then it jumps a generation. So my brother then, or my husband has a sister, I have a brother. Well, they have their separate respective lives. Do they really know the child? Do we like them? Do we like the way they rear their children? So the court would pick one of those people. If no one's available, the court will pick a public fiduciary. That's someone who does not know my children. That's somebody who does not know what bank accounts I have. This person would be in charge of selling my house, going through my personal property, selling my jewelry to raise money. I mean, it would be a nightmare. So when to do all this estate planning? Now. Absolutely now. Even if it is going down to your local bank this afternoon and naming a beneficiary on your checking account. Do it. It avoids probate. It's easy. It's free. It's simple. And at least you are pre-planning to not only protect yourself and make sure that you have those people in charge that you trust with the most personal and intimate things that, to stand over someone's bedside in a hospital and determine as to whether or not you should pull the plug is one of the most personal and emotionally upsetting decisions ever. I want to be able to choose who that person is. I don't want to leave it to some court-appointed person. Also, I want to make sure that when I die, anybody who's grieving the chaos in their life of losing me, that then they don't have the chaos of, oh, well, she didn't have a beneficiary. Oh, you need to open a probate. Oh, you need to do this. Oh, it's all public record. I mean, talk about kicking a dog while it's down. So when to do a trust, when to do a power of attorney, when to do a will, when to name beneficiaries, now. And if you need a trust.
One other angle specific to PMD Alliance and in our situation here. One way of leaving your legacy, making your estate last beyond your life would be through charitable giving. So, can a nonprofit be a beneficiary of a trust? Like, how do you incorporate giving with your client's estate planning?
Okay, so glad you brought this up. And I just looked at the clock. My goodness, can I talk a lot? Okay, so charitable giving. So here's an awesome thing about estate planning. Sometimes you have taxable assets that would really, for example, I have a lot of clients who leave their IRAs to 501c3s or charities. Take the PMD Alliance, for example. Let's say that I have this old IRA and whoever I'm going to leave it to is going to have to pay tax on it because of the Secure Act. They have to liquidate it within 10 years is kind of a nightmare. If I leave that to a charity, it goes 100% to the charity. They pay no tax and they can liquidate it outright. Also, with the charitable giving, you can also make more lifetime gifts. And I don't know, I'm sure the PMD Alliance does it. You can do, like a charitable remainder annuity trust. You can do a charitable remainder unit trust. There are so many ways to give and to achieve your charitable aspirations and your goals through your estate plan. I also have people do this a lot. So for example, let's say you only have one child, you're leaving everything to the one child. Well, what if the child predeceases you and there's no one else you want to name behind them? I always recommend to clients to name a charity after, because you don't ever want your estate plan to fail. Because if it fails, it goes back through your bloodlines. So mine would go to my parents. If they're not living, then to my siblings. If they're not living, it goes to my grandparents. Of course, they're dead. Then it goes to it would go to like my aunts and uncles and cousins twice, third removed. So if I have everything to my husband, and if my husband doesn't survive me, everything to the PMD Alliance. Great. At least my charitable aspirations were fulfilled and I have a catch-all. And can the charity also be named as a fiduciary? Yes, they can. Obviously, you always want to check with the charity first. I've had a couple charities freak out when they're like, wait, I'm a trustee of what? So you want to check with them first, but they generally always have fiduciary services or someone they recommend to do that for you. The best thing about that is they're not only a charitable organization, they get 100% of the money. Another great thing about providing for charities in your estate planning documents is the specificity you can have. So every charity loves a general device. So it's just $1 million to the PMD Alliance, do with it what you will, okay? Some people say, however, one thing that I really love about the PMD Alliance, let's say these educational seminars. So they say, okay, I'm gonna leave $20,000 to the PMD Alliance and I would like them to spend it on educational seminars. So you can direct it, you can actually control it and give that charity direction as to how to spend those monies. A quick funny story, we have a local animal shelter here called the Animal League of Green Valley. And I have a client who's leaving a sizable amount to the Animal League. And she loves dogs, but she hates cats, like hates cats. And of course, the Animal League does both dogs, cats, pigs, yeah, everything. She's like, over my dead body is one dime being spent on a cat. I was like, okay. So in her trust, we have specifically said that any and all money is going to the Animal League shall be used only for dogs, not one dime on cats. And she even went a step further. She is a huge lover of senior dogs. She is the one, these angels that walk among us that go to the shelter and adopt dogs 10 years and older. And some of them are only with her, I'm getting goosebumps, for like 6 months. But the quality of life they have for those 6 months. So she is leaving quite a considerable amount. Dogs only, no cats, no general overhead for the Animal League. So you can't pay your electricity bill, you can't expand your building, you can't pay director's salary, you can't do anything. Strictly for the dogs, strictly for senior dogs, and specifically for treatments that they would not otherwise pay for senior dogs. So it's just so heartwarming because, some of these elderly dogs are going to get chemo treatments. Some of these elderly dogs are going to look into arthritis medication, hip replacement, things that people wouldn't spend that kind of money on a 10-year-old dog, when it could go to a younger dog that has, a better chance of survival. But that's her passion. So trust, I have clients that, don't really like humans, which is fine. And they're leaving it all to charities. And each one is so specific and they have this great thing. And some of them say, I don't want my name on it. Other ones say, I want it in loving memory of my mother. It's something that really touches your heart, and that trust completely controls it and dictates it. And I will say that some of the best beneficiaries that we ever deal with on any and all trust administrations that we have are the charities. We send them an accounting or we send them a proposal for distribution. And they FedEx overnight it signed back, and they're awesome. And so it's a really great way to do that, especially if I have a lot of clients where their children, they did a great job being parents. Their kids are fine. Their kids probably have more money than mom and dad, and they say, I want to leave it to charities. And they do, and it's wonderful. And it really benefits not only your local community, but also the national organizations like PMD Alliance, because I'm sure a lot of the monies you guys get, you funnel then to other groups that are underneath you. And you guys can direct all of that through your estate planning documents, and it's wonderful. You can even name them as a beneficiary on your IRA. You don't even have to let them know. Trust me, the IRA financial advisor will let PMD Alliance know if you pass away. It's a great way to achieve those goals. Absolutely wonderful.
Wonderful. Well, I always threaten my kids that if they don't go to school, I will haunt them. But I'm so glad to learn about is it dead hand? Is that the term? It's
Dead
kind of
hand
a macabre
control.
term, but now I don't have to threaten haunting. I can put things in
Yeah.
a trust and be
And
very
you could
specific.
also say if they don't achieve the qualifications in the trust by, I don't know, age 30, then any monies remaining in the trust goes to the PMD Alliance. So use it or lose it. And trust me, kids respond very well to that. They do.
Well, I said that this topic can be dry, but this was wonderful. This was not dry.
Thank
This was
you.
fascinating and empowering. Thank you to everyone for your amazing questions. We didn't get to everything, so thank you for that offer, Phoebe, for to ask follow-up questions. And I know Maureen put her email in the chat as well. So we do have to say goodbye right now, but we want to keep the conversation going. So if you have a question, get it to us and we'll get it answered for you. But we will say goodbye right now. So I invite everyone to turn on your camera, do a gratitude wave to Phoebe for
Thank you guys so very much.
being
Thank you.
so knowledgeable and so appreciated. Okay,
Thank you all.
everyone.
All right. Bye-bye.